All right, this video is going to talk about the midterm you just took. And to help you review your midterm, I've provided six different things. First, a video reviewing the substance, which is what you're looking at right now, and rubrics that break down the substantive law as well as the skills that you'll find on the midterm lesson page. And then, just so you know, the rubric that we're going to go over or that's posted includes every possible argument in detail. So I wasn't expecting you to cover everything in the rubric, but it does account for all the different arguments people could have made. And then the skills, it really explains how the scores relate to letter grades and the bar exam. So I definitely take a look at that too if you're confused as to how the scoring worked. In addition, you each got a breakdown of your score for each category, as well as individual feedback with some comments on it. And we'll have a class explaining the scoring coming up. But you should have been emailed this by the registrar. If you haven't got it yet, just let me know. So these are the six things that I'm hoping will help you improve and understand why you scored the way you did on your midterm. In terms of the scoring, like I said, scoring will be explained during class, but this is a general breakdown of the points you could have received. Style and organization was 5 points. And I really look at whether you used Iraq, if it was easy to read your arguments and counter arguments, if you're using headings, subheadings, paragraphs, white space, not a lot of grammatical errors, if you appropriately use see above or supra. So basically, anytime I didn't have to pause and see what you're trying to say, I wouldn't dock points. But if I ever had to stop, I would dock zero point 0.5 because you shouldn't have your grader trying to figure out what's going on. It should be a pretty quick and fast read because bar examiners are really reading it in 3 to 5 minutes. They're not going to stop to try to figure out what you're saying, right? So style and organization was 5. Now let's just go through the rubric individually, where we have declaratory relief as our first section. And in the rubric, you'll see that the inferences are underlined throughout the rubric. So you can see, well, what was a fact that was provided and what is an inference, which is the explanation in terms of how that fact relates to the law and what you're thinking in your head that you should have written on the paper. If it's blue text, it's usually bonus or a nuanced argument. So those I don't necessarily expect you to get, but if you did get it, I did award points. So let's start with declaratory relief. Part A asked you to determine if Piper is entitled to declaratory relief after filing a lawsuit against Dentacare requesting declaratory relief that the company's vaccine policy is unconstitutional. The rule here has two parts, uncertainty related to the party's rights, status, or other legal relations, and a justiciable controversy. Most people got this rule, but they did struggle a little bit more with the justiciable controversy. But let's start first with uncertainty. So for uncertainty, the more obvious argument was P's argument, which is yes, although she stated she wouldn't have issues complying with any existing or future COVID company policies, there are issues related to whether the company's policies are unconstitutional. So basically asking you to pick up on that First Amendment issue and whether there's a violation of her constitutional rights and that needs to be resolved by the court. The more nuanced argument that some people brought up was D's argument, which is technically she agreed to comply with these policies. So there's this verbal agreement between her and the company. There's real no uncertainty as to their rights. It should just be enforced. Right? But here it's more likely there's some sort of uncertainty, especially because we're dealing with constitutional rights. Justiciable controversy was the one that people struggled with a lot more, mostly because not everyone knew the sub rule. So some people were trying to talk about it, I guess, abstractly, which is a very hard thing to analyze. But the three things that help you determine if there was a justiciable controversy are whether there's an actual definite or concrete issue, basically not hypothetical, abstract, academic, or moot. There's some sort of determination of legal rights that is necessary. And then two, whether there's adverse legal interest between the two parties. And then three, that specific relief is actually requested. And this controversy, if that relief is granted, will, be resolved by the relief requested. If you had this sub rule, it was actually pretty straightforward in terms of the analysis. Definite and concrete, yes, P is about to be fired in 2 weeks. D also has 500 employees who will be impacted by this new policy and could lose their job. This is not hypothetical. It's impacting real people. So it's definitely something that needs to be resolved now. As for legal relations, P believes these policies are unconstitutional and D believes that it's legal. This impacts their employment relationship and whether it will continue or not continue, right? And then finally, specific relief requested. Yes, if the declaratory relief is granted, then it will determine whether P will stay employed with D and how D should treat the rest of its 500 employees. So if you had this sub rule, it was pretty straightforward in terms of how you can apply it. You can see where I have the facts that aren't underlined, and then the inference, which is explaining how those facts relate to the rule that is underlined. And then you would have got points for citing a fact as well as putting in the inference here. The one that people struggled with the most, I think, was the specific relief requested, where they said, yes, relief is requested, but you do want to talk about, well, what type of relief is requested? And if it is requested, would that resolve the issue between the parties? And the answer here would have been yes. Now, I also gave points for concluding on each sub issue. So you had to conclude on whether there was one, uncertainty, and two, if there was a justiciable controversy, or, if this element weighs in factor of D or P, depending on what, was required. And then points for concluding on the overall issue. So after you've looked at all the factors or elements, saying, who wins and why. And then, of course, there were bonus points available for using policy or cases to conclude one way or the other. But I think in this midterm, no one actually did this at all. More people picked up bonus points from arguing multiple different facts or arguing multiple different sides, like counter arguments that were more nuanced. So declaratory relief should take about 10 minutes or so. The big point, I guess, getting section was preliminary injunctive relief and equitable estoppel, which is the equitable relief. So let's start with preliminary injunctive relief. The question is, well, Piper also filed for preliminary injunctive relief. She's requested that the court stop Dentacare from enforcing its policy and terminating her employment. And then you have two prompts. One, should the court grant her preliminary injunctive relief? And you assume Piper will likely succeed on the merits of her claim. And then two, Dentacare argues that the doctrine of equitable estoppel prevents the court from granting Piper injunctive relief. How should the court rule? Let's start with the first issue, which is the preliminary injunctive relief. Should the court grant this preliminary injunction of relief? And the first thing you should have done, which most of you did, but a couple of people didn't, was to state the rule up front, right? Where you need irreparable harm, likelihood of success on the merits, balancing of hardships, inadequate remedy of law, and the public interest would not be disturbed. If you talked about them in a different order, I didn't really care, as long as they all showed up at some point. If you didn't put the overall rule, I might have docked like 0.5 or 0.25, just because I want you to really get in the habit of putting that rule at the top, since the graders do look for that. And then after, you should have split each section up. For those of you who bunched it together, I did -1 point or 0.5 because it was really hard to grade. And I keep saying, remember, use headings and subheadings and really separate these things out so it's easier for the grader to follow your analysis. And the first thing you should have addressed was the irreparable injury. Here's a sub rule. An injury is irreparable if it is severe. Certain grade cannot be fixed, except for the injunction. Those of you who did not have this sub rule had a really hard time analyzing this element or factor. And that really hurts you in terms of the inferences because you were just citing facts or talking about your feelings generally and not really applying it to actual law. Those of you who did have this sub rule pretty much got almost full points for this or more. But you needed at least one of the arguments for P, which is, well, her partner's lost her job, she has no income, they can't pay their bills, she's going to be terminated, which that's a fact, but that means it's certain and great because she can't survive. There's no way for her to continue to support her family, right? That's pretty great, and it's certain to happen. It's going to happen in 2 weeks. The other argument you could have talked about was the vaccine or her religious beliefs and how requiring her to get the vaccine will interfere with her First Amendment rights, and she has the right to freely practice her religion. And that's certain because she has to either get the vaccine or not, right? If she doesn't get the vaccine, she'll be fired. If she does get the vaccine, it interferes with her right to practice her religion, which is a fundamental right. So you could have argued one of those two or some other version, a combination of it to get points. And then a bonus would have been, well, technically D might argue that she hasn't actually suffered harm yet because she can still get vaccinated or avoid being terminated. and she has agreed in advance in her interview that she would follow all existing, existing and future company policies. But that's much weaker. I would have given bonus points if you went that way, but it's just a much weaker argument because it's quite obvious that she's going to suffer some certain and great irreparable injury if she's required to get the vaccine or she's required not to get the vaccine. So we need to kind of figure out before they resolve the permanent injunctive relief question, what's going to happen while the lawsuit's being resolved. So lots of points available here. Likelihood of success on the merits. Some people actually went into the merits of the claim and talked about it a little bit more, but you literally just needed to put the facts say to assume Piper will succeed on the merits of her claim and then moved on. There weren't a lot of points here available, maybe like 2 points. And if you wasted time here, you could have got more points elsewhere. Those of you who actually wrote that it's actual success on the merits, I didn't minus points, but just remember preliminary injunctive relief is likelihood of success and permanent injunctive relief is actual success on the merits. Inadequate remedy at law, this was the other section where there was a lot of points. Similar to irreparable harm, if you didn't have the sub rule, I noticed you really struggled to explain your thoughts. But if you had the sub rule, you did a pretty good job explaining why damages were certain or uncertain. A lot of people talked about multiple lawsuits in terms of the other 500 employees suing the defendant. But remember, multiple lawsuits really just deal with the plaintiff having to continually sue the defendant, less about what other people or third parties have to do in relation to the defendant. So here, whether multiple lawsuits would result between the plaintiff and defendant is kind of questionable. I'm not sure they would have to sue again on this issue. D, being insolvent, the cause of action involves unique goods or land. For the unique goods or land, some people were talking about the situation being unique because she's a dentist, but that's a unique service or unique situation. Unique goods or land are very specific, and we're not dealing with either one of those. So if you made that argument, you wouldn't have got points for talking about unique situations or unique professions. And then finally, there's no other way to protect the right besides granting injunctive relief. And so here, with what you would have got points for, you need at least one of P's arguments is there's no other way to protect the right. P's First Amendment rights will be violated without this injunction being granted. So we must, allow her to practice her religion and keep her job. That's what she's going to try to argue. Also, damages are uncertain. It's very difficult to quantify violations of someone's constitutional rights. So you could have argued one of these two. And I think you needed at least to have also a defendant's argument. But if you had 2 arguments for P and you talk about both of these, you would have still got full points because you would have got bonus points for talking about the other one. And then if you missed D's arguments, it would have just washed out. But D would counter that, well, D can keep the policy for all other employees, but ordered to make an exception for religious reasons versus invalidating the entire company policy. So there are other ways to protect the right besides granting this injunction to P. And then damages are uncertain. Well, P's injuries can be measured by her salary. They can pay her the monthly salary until she finds a new job. So maybe there is an adequate remedy at law where a preliminary injunction isn't required, right? This is probably D's strongest argument here out of all of them, as well as the balancing of hardships, I guess, that preliminary injunction injunctive relief should not be granted. But again, whichever way you concluded here, it didn't really matter. For irreparable harm and likelihood of success on the merits, those were more likely yes, but this one could have gone either way. Balancing of the hardships could have also gone either way. The sub rule was the plaintiff's hardships must be substantial compared to the defendant's hardship. And there were tons of facts you could have used here, right? We have the COVID being transferred from person to person, D's trying to protect its staff and employees who shared concerns about the dental treatment, which is contact with the mouth. The vaccine supposed to reduce COVID transmission. There's all these facts about underserved communities having higher rates of COVID, which is the population that Dentacare serves with its 500 employees. So it's a large company serving this. And all of those facts go to the hardship related to D, which we'll talk about in a second.